Welcome to Moose Court, Landlord, Tenant with Judge Middleton. There was a previous hearing. It was demand for payment, and what we learned from that one is the landlord is a bit of a jerk, and he's probably liable for a lot of bad things that he's done to these tenants. So here's the follow-up hearing. Let me know what you think in the comments. Here we go.
We determined that rent was $7,937.26 through June. Court costs were $222.70 for a total of $8,159. The defendant raised a number of issues regarding the covenant of habitability of these premises, and I indicated that we would discuss this further. If we had to set a hearing on the matter, I would probably be inclined to issue an escrow order that they start to pay the rent to me pending any further hearing in the matter. So, Mr. Landman, I'll defer to you first. What's your understanding here?
Your Honor, I received a voicemail from Ms. Bauer earlier this morning while I was on Zoom in a different court, indicating that she was going to be appearing. I did attempt to call her back, but her voicemail was full. As far as
she's very popular.
She is far more than I, and I guess that's beauty before age. But in any event, as far as the case is concerned, I know that the court also perhaps suggested to the tenants at the prior hearing, according to Mr. Burns's notes, that they might be more inclined to move out. I do not believe that any money has been escrowed anywhere as far as I know. And so you do have a very, very, very sizable balance. I suspect that with Ms. Bauer being involved, that the case is going to need to be set for a trial or a contested hearing. And so certainly whatever the date is that best works out with the court's schedule, we'll make the trip down and have people present. I think Mr. Burns may have presented at the last hearing that we believe that a large portion of the problems with that are alleged by the tenants is, at least in whole or in part, the direct result of their own conduct. This is a home that never had an issue prior to the tenant's arrival, and there has been evidence that there were things that were flushed down the toilet that should not have been, that therefore resulted in an issue with the sewer system. So that's our position on this. We believe that the full balance is due and owing, and that when this case ultimately comes before you for a determination, we would be requesting that a judgment enter.
Well, the rent is $995 per month. And if I do an escrow order, it'll be $995 for June and $995 for July. So the fresh hours are going to owe me about $2,000 right off the bat, Ms. Boyer and Mr. Freshour. So that's when I suggested perhaps you might just vacate and we could fight about the money, because it's been some time since rent has been paid. As I said, the arrearage is similar to the last one, over $8,000. Ms. Bauer, what's your position?
Thank you, Your Honor. I have discussed the matter of escrow with the defendants, and at this point they are interested in and prepared to participate or satisfy that escrow obligation from the court. To make the record complete from the defense's position, they are taking the position that rent due, if any amount should be due, should be abated due to the conditions of the premises, and that's under MCL 600.5741. But we've also got some concerns regarding the accounting of the ledger and the utility assessments. For starters, I'll indicate that 1,000 of the dollars that were just asked for are exclusively late fees, but also there's some unsubstantiated and uncommunicated utility assessments that may be in violation of Public Service Commission rules. We've also got concerns about illegal conduct on the part of the plaintiff, or at the very least threats of illegal conduct on the part of the plaintiff, namely retaliation. This case was only brought shortly after the defendants contacted the county public health authorities. And then there's also threats of utility shutoffs, not just utilities that are tenant paid. And there is actually a concern about some fraud in the inducement of this contract from the very beginning. Ms. Bauer has 3 children. She applied for 1 unit, was approved for 1 unit, and then suddenly moved into a different, smaller unit. So at this point, I have discussed with the tenants, the defendants, a couple of different options, and they are prepared and interested in paying the escrow order that the court would set. And because of that escrow order, the defense would ask for an extended period of time for discovery. That meaning that escrow order protects any further injury that the plaintiff would incur. But we are seeking communications, or engaging in communications with, and are seeking some records from state and local regulators. And getting those records often takes time, because these are large government body actors. In order to get to the bottom of this, obviously I've heard the position of the plaintiff. It seems, have some extended discovery. But no matter what, even if the defendants are responsible for some portion of damage to the unit, which we don't believe, because the images, or the issues, with the plumbing started mere weeks after the defendants moved in, that does not excuse or justify the plaintiff dumping the sewage waste onto the ground of the park. I'm prepared to show you today pictures of fecal matter that have been dumped on the lot, that are all over plaintiff's property, at the hands of plaintiff's employee. So,
I don't need to see that. I've seen enough this week. I saw a house on Wednesday that may be one of the worst ones I've ever seen.
Thank you, Your Honor.
All right, so they're willing to pay the escrow. I was gonna try to rush to a hearing on this, but it doesn't appear that's necessary. There will be an escrow order in effect, Mr. Newsom, so they're gonna pay the court June's rent, July's rent, and August's rent, because I'm looking to August 13th at 1. Let me check that. What do I have on there? 1:30. Does that work for you?
That should be fine, Your Honor.
That will be a live hearing.
I am also available, Judge.
All right. Is that enough time?
We'll make it work.
All right. I don't want to go beyond that. I've got the judicial conference. Judge Pattison has some time off. I have some time off. And so I don't want to go all the way out into September. And there happens to be an opening there that I've just filled. All right. So I'm going to do an escrow order. $9.95 per month for June. We're in June, July, and August. So you'll pay the rent to the court. We will send you an escrow order, and we'll hold it. If we find at the end that your rent is abated and you don't have to pay any rent, we'll give the money back. If we'll find that it's partially abated and some or all money is due to the plaintiff, we'll give it to them. But when we go a further month without paying any rent at all, there's no inducement for the defendant or the tenant to rush to any resolution. And if they do owe the money, then they're that much farther behind. So that's the purpose for escrow. It precedes me by 50 years. It's probably as old as the district court is in the Summary Proceedings Act. So let's recap. Meg Bauer has filed an appearance. She's raised a number of issues which could affect things. There's issues of abatement, issues of the amount of late fees, issues regarding utility assessments, issues regarding retaliatory eviction, for violation of the shut-off statute. I'm not sure we have enough time scheduled for this. It's like biting aluminum foil or having bamboo stuck down your fingernails, but we'll take as much time as we need to resolve it. Now, in the meantime, if you decide you want to just move somewhere else, which I certainly had encouraged before, and you do vacate, let Ms. Bauer know that. So let's say you move in July, you wouldn't have to pay August rent. We may still need the hearing to determine who owes who how much money.
Is there a supplemental on this case, Judge?
No, Your Honor. It's possession only.
Possession only. So
there's not a request for money judgment.
So if you vacate, the case is over and they got to start over again in a money damage case. So that's something you may consider, but I'm willing to hear it. Yes.
Sorry. I was going to try to get this before we get into your summation, but the defense would like to request formal discovery. We're certainly going to work towards resolution. I did discuss a couple of possible alternative solutions with the tenants, but in light of the seriousness and the volume of the amount, we'd like to just make that formal request for discovery.
Discovery is a strange and vigorous thing in district court, but I will order a mutual discovery.
Thank you, Judge. I apologize for not
no need to
sneaking that in there.
The discovery rules in district court are not nearly as clear as they are in circuit court. Ms. Boyer or Mr. Freshour, do either of you have any questions?
No.
All right. My strong advice is you stay in contact with your lawyer. She does a lot of this. The plaintiff, Mr. Landman, his law firm does a lot of this. Very often the lawyers can work the thing out short of a hearing, but I've got 3.5 hours blocked out for a hearing on August 13th at 1:30. All right, you're good to go.
So for the escrow, I'm sorry. When do we start paying that out?
You should pay both of them by, you'll get one soon.
Okay.
It probably won't be there until July 1st, but you're going to owe June and July. So certainly in the month of July, you should pay that.
Okay.
If you don't pay it before the hearing, you don't get a hearing. They automatically win.
Got it.
So you need to make sure it's paid at least by the hearing date.
Okay.
But that's a good question. All right, let's hope we can get somewhere on this. All right, you guys are both good to go.
Thank you. Have a good day.
I think Meg Bauer was born to be an attorney. This is, I'm pretty sure, her first job out of law school. And she operates like somebody who's been at it for 50 years. I also think the landlord is screwed on this one. What do you think? Let me know in the comments. And it really helped me out if you gave me a thumbs up and subscribed. And if you want to tip me, hit the thanks button below. Thanks a lot for watching the video.